Hello everyone, welcome back to my channel, and in today's video we will be summarizing the fifth unit of our constitutional development that deals with the Supreme Court of India. Precisely a short topic of Supreme Court of India, because we have all seen with regards to the history of our constitutional development how the constitution was enacted, what were the steps in the same, and similarly what were the developments of Supreme Court, how Supreme Court was first established, what were the changes that had happened, and how do we led to the establishment of Supreme Court of India. So basically it is a brief history with regards to Supreme Court of India. So Supreme Court of India is the apex judicial body of India, that is the highest court of appeal as we call as, and a court of record as well. So it was established in 1950 under the Constitution of India, which we will be discussing, and it is the guardian of the spirit of the Constitution as the highest court of appeal of the Constitution of India. Then we all have studied with regards to the Federal Court of India, which was from the year period of 1937 till 1950, and after the Federal Court was we cannot say it was abolished, but rather it was changed to the Supreme Court of India, and it came into existence on 28 January 1950, which is located in New Delhi. Then what exactly is the composition of Supreme Court of India? This is very short topic. First, initially there were 8 judges. Presently there are 34, including the Chief Justice of India, who is the senior most Chief Justice of India or senior most judge of the Supreme Court, who is appointed through a collegium system via the appointment of President of India, that we can say, or the recommendation of President of India. Like that is appointed. Structure of the Supreme Court with regards to, there is a permanent bench in Delhi and the constitutional benches for interpretation of constitutional matters. So constitutional bench consists of odd number, that is 3, 5, 7, 9, 11, 13. Whenever there is a question of law with regards to the interpretation of constitution, these benches are set up for specific matters as well, that we will see further on that how constitutional benches are set up for the interpretation of Constitution of India as well, with regards to various different laws which challenge the constitutional validity. Then there are divisional benches, single benches as well for various jurisdictions which are there. Then coming to the part of jurisdiction, in shortly, if we take the jurisdiction part, which we will learn in detail when we come to the 3rd and 4th semester, but as far as this semester is concerned, very short part is being covered of Supreme Court. Main focus is on Federal Court, which we have already studied in detail. Supreme Court, we just need to know the basics as of this semester is concerned. First, there is original jurisdiction, which is under Article 131 of Constitution, where there is a dispute between one state with other state, one state or a group of state against the government of India, or 2 or more states. Next is the appellate jurisdiction, which is under Article 132 till 135, where you are aggrieved by the decision of High Court. Then there is a grant certificate which needs to be issued in the period of 60 days. Then you can appeal criminal civil related matters in Supreme Court from directly High Court. Then 136 is a special leave petition, SLP, which I have not mentioned, but you should know that special leave petition, where you need special leave where the certificate is not being issued, you can directly move to the Supreme Court if you are aggrieved by the decision of High Court. Then this is a special jurisdiction given to the Supreme Court, where the President can seek advice or opinion of the Supreme Court, which is under Article 143. And the next is the review and curative jurisdiction, which is regard to reviewing the judgments that is given by High Court, whether it is correct or not. And there are different powers and functions of the Supreme Court of India. First and foremost, the fundamental right that is given under Article 32 of the Constitution of India, that is, we can directly move to the Supreme Court for the issuance of writs, that is prerogative writs. There are 5 kinds of writs which we will study in detail further on: habeas corpus, mandamus, prohibition, certiorari, quo warranto, and these writs can directly be issued by moving to the Supreme Court when there is a grave violation of fundamental rights. But first you need to prove that there is a grave violation of fundamental rights, then and then only the Supreme Court will entertain your matter. Next is the judicial review of laws and executive actions. So in short, you need to understand what judicial review is. Judicial review is basically when certain laws are there, these laws violate our fundamental rights, then if these laws are violating our fundamental rights, then the court has the power to curb that law and take it through a judicial review process to making it confirm, or to confirm that whether these laws are violating fundamental rights or not. Then advisory opinion of the President that we have seen. Then appellate jurisdiction also, it comes under the powers and functions. So next, with regards to doctrine of precedent, so that is our article 141, that there is a doctrine of precedent. Precedent exactly in this instant case means when a decision is given by Supreme Court, it automatically is declared as law, and all the courts, subordinate courts, lower courts are binding upon that incident or the precedent given by Supreme Court of India, and this ensures that there is a consistency and predictability on law. And the doctrine of stare decisis is followed. So this doctrine of stare decisis, that all the decisions given by Supreme Court are binding upon the lower courts. This is regarding the doctrines. Then in all of these cases, there are a lot more cases, landmark cases, which we will study when we go in depth with regards to constitutional law. That is in our third semester, constitutional law first. But main you need to know that what are landmark judgments exactly. So landmark judgments covers those judgments given by Supreme Court, High Court, whatever it may be, which interpret the constitution itself, which interprets and expands the scope of the Constitution of India. So main cases you have already heard, you will always hear them, that is Keshwananda Bharti versus State of Kerala. This is the basic structure doctrine with regards to what constitutes as basic structure. The parts of the constitution which cannot be amended by way of the constitutional amendment comes under basic structure doctrine. Then Maneka Gandhi versus Union of India. This expanded the scope of our Article 21, where Maneka Gandhi's passport was impounded by the Union, and she went to the Supreme Court with regards to violation of her fundamental rights, that is 14, 19, 21, right to equality, right to freedom, and our right to life. That is the golden triangle of our Indian Constitution. Then Navtej Singh Johar versus Union of India, that is decriminalization of section 377 of IPC. There are a lot more of these landmark judgments that we will be covering when we will deal in detail with regards to constitutional law. So this was all regarding the Supreme Court of India, and I hope, though this topic is not extensively covered in this video, but rest assured, in our third and fourth semester we will go in detail as to how Supreme Court's jurisdiction and all functions. For this semester is concerned, you need to go through depth of the federal courts and the history, because the subject itself is named as constitutional history, constitutional development, not with regards to the present condition or the constitution. We will study constitution in depth in our third and fourth semester. So till now, I hope everything is clear. The PPT of the same will be provided in the description, and if you want to learn more regarding, so please you can subscribe to my channel. Thank you.